Welcome, everybody, to today's Lunch and Learn webinar. I am Luke Wachob. I'm the Senior Director of Communications and Policy at People United for Privacy Foundation. We have a great discussion lined up for you today with our guest, Allen Dickerson. Allen is a partner at Baker Hostetler, where he counsels organizations engaged in the political process and represents clients in constitutional and administrative law cases. Prior to joining Baker Hostetler, Allen was a commissioner on the Federal Election Commission from 2020 to 2025. So he brings a very recent perspective on the commission. He served as chair of the FEC in 2022 and vice chair in 2023. Prior to joining the FEC, Allen was legal director of the Institute for Free Speech, where he led a nationwide First Amendment litigation practice focused on campaign finance and political law. That also happens to be where I met Allen, where I was getting my start in DC. We are here today to talk about Allen's experiences at the FEC and why campaign finance law matters for nonprofits and their donors, and I would argue seems to matter more and more as the years go by. We may have time for an audience question or two at the end, so feel free to drop those into the chat. Although it is a short half-hour discussion here today, we will try to respect your time. And with that, Allen, thank you for joining us on the People United for Privacy Foundation Lunch and Learn webinar.
Thanks for having me, Luke. It's always a pleasure to talk to you and your colleagues.
Well, I think we should probably start at a threshold matter of, how does the FEC affect nonprofits and their donors? The Federal Election Commission, which I've always thought is kind of a misleading name because it's not involved in the administration of elections, doesn't do vote counting or registration or anything like that, but rather regulates campaign finance. So we primarily think of the FEC in the realm of candidates, political parties, PACs, super PACs. When we think of nonprofits, we tend to think of the IRS as the big government agency in the room, and indeed it is. So I know this is a topic you could fill our entire 30 minutes with, but I'll ask you to be brief if you can, and just give us some basic background here. How do campaign finance law and the FEC affect nonprofits and donor privacy?
Well, I appreciated that introduction. I tried every year of my time on the FEC to convince my colleagues to ask Congress to rename the agency in a way that was slightly less misleading, but at least certain of my colleagues seem to prefer the vainglorious Federal Election Commission. So it's a very fair question. I think historically the FEC had more of a role in sort of policing bans on speech that have since been declared unconstitutional. The result has been that sitting here right now, the FEC largely is a donor disclosure agency. The reporting regime and the disclosure portions of the law are what have survived judicial scrutiny, at least to today. And so most of the FEC's time is spent on disclosure questions, both, expenditures by organizations, but largely, the contributors who are putting the money into the political debate. What that means in practice is that the FEC is kind of the dress rehearsal for these conversations about donor privacy. And I'll give you an example of how things metastasize out of the FEC space in sort of larger conversations. For the longest time when I was there, we would have these investigations that would come up because someone would have, given a contribution to a super PAC or, some money was spent some way on political speech in a way that people felt was insufficiently transparent. And we got into this really big fight about this because our actual regulation talked about, identifying the original contributor. And the Office of General Counsel, over the years, without kind of adult supervision, had decided to interpret that as the original source. I suspect this is a pretty sophisticated audience. The term original source probably has come up to you outside of the FEC context. I used to make the joke that the original source of the money is always the Federal Reserve Bank. Like, it's not a helpful concept to talk about the original source of money. What is helpful is to distinguish between people who are, actually giving the money and people who are, sort of just involved in some way in a causal chain of economic transactions. And that central concept of trying to get regulators to just concentrate on that last step at the actual sort of agreement between a contributor and a recipient as to what's going to happen, and not just go down the rabbit hole of who gave who to whom, 6 or 7 or 8 steps deep, was just a perennial struggle. And I know, Luke, you've seen that a lot down in the States and in nonprofit debates that have nothing to do with political law. But it all started with us.
Yeah, I love that term you use, a dress rehearsal, because I think that it really speaks to, when we defend nonprofits, their right to donor privacy, their right to free speech, we're usually not talking about anything that would be considered campaign activity at all. And yet, so many of the important fights that matter for us end up being, downstream of campaign finance, or that's where they kind of first show up. So I think we see that a lot. And going down the rabbit hole, that is a temptation that many regulators, as well as many activists and sort of grandstanders in politics, engage in. But one thing we hear a lot is this term dark money, nonprofits that get engaged in almost any type of political issue, whether it's, sometimes spending a bit of money to speak about a candidate's, background, or talking about a policy issue. Sometimes even filing amicus briefs, any attempt seemingly to have any kind of influence over policy or how people think about government, nonprofits get tagged with a sort of dark money label. What is your opinion on that term, dark money, and people who say that Congress or the FEC or somebody ought to do something to rein it in?
Well, I'm actually gonna start on the second part of that, like the do something. I think that's exactly right. It's always do something, and that's the something's doing a lot of work in the conversation, right? It's very, I think, hard to have a concrete conversation about this because dark money really doesn't mean anything. Like it's just turned into a pejorative about it's always the other side that's engaged in dark money, and I think that's a real tell. So I think there's two practical problems to sort of answer the question. I mean, one is to your point about political, there's no agreement on what it means to do something that is political. And that's been a problem, for at least a half century now about sort of we're in a self-governing republic. When free people talk to each other about the sort of society they want to live in, it's very difficult to draw lines between discussions of policy or discussions even of sort of, aspirational kind of wishes for the country and concrete conversations about, specific bills or policies or executive orders or heck, judicial opinions. Um, and then, moving into the campaign and then finally into the election itself. And that kind of that continuity, that sort of continuum rather, that has always bedeviled this conversation because no one really can find a place to draw the line where you're only reaching things that are truly about who's going to be elected to a particular office, or in the lobbying context, a particular bill, a particular proposal, and sort of the slippery slope into regulating all of civil society generally. And I think that's the first problem is just like, it's a very difficult thing to do in practice, largely because people don't really agree on what is and isn't political. I mean, I historically, discussions about religion were in fact, coded politically. Discussions about lots of cultural questions code politically now, and spending money on those questions, I think, there's a debate about we got to get this dark money out and have people, not quietly influence elections by talking about policy. It's not clear to me that people who say that really want to live in the resulting country, where you have essentially, state surveillance down to a pretty granular level of nonprofit activity that really is only tangentially related to politics.
And as you said, dark money lives in people's minds as something that the other side does. It's not for their nonprofits. Our nonpartisan NGOs, our experts, their, grifters and their dark money groups. It's a very sort of eye of the beholder thing. And the term dark money, I think, has created this perception that this is kind of a new phenomenon, having these groups engaged in civic life. But it's really the opposite that's true. I like you mentioned it's been, bedeviling this law for about half a century. It's that really that era of disclosure and regulation is much more of the anomaly in our history. Americans have always had strong privacy rights and strong First Amendment rights to form organizations and to go out and try to better and improve the world around them as they see fit. And as you note, that often leads itself to some speech or activity that somebody is going to classify as political. So dark money, not a technical term in the law, correct? Just sort of a piece
No.
of rhetoric people throw around.
People keep trying to make it a technical term and they flounder on practical difficulties.
Well, thank goodness for that. Um, and I suppose if the argument for donor disclosure is often motivated by these concerns about so-called dark money, then the argument for privacy is often about protection. Usually, that is protecting people's right to privacy of conscience or their ability to exercise First Amendment rights without being exposed to people who might retaliate against them, whether that's government official who might treat you unfairly, or political activists might try to get you fired from your job, or even just your neighbors or your family, even people who might try to pressure your decisions in some way that we think is inappropriate. But recently, we are seeing a really disturbing trend in political violence, including in Minnesota, where some lawmakers were attacked at their homes. That has led a number of states to sort of reconsider laws that are exposing home addresses, particularly those belonging to elected officials. Now, when you were at the FEC, this is a long wind up to asking you about an effort you led that is, I think, sort of related to this to formalize a process for people who give money to campaigns, but who would be at risk if their information were disclosed, to request redactions in public reports. How did that come about? And what happened on that process?
Well, I think it's a good framing. You know, the when I first started talking about this with my colleagues at the commission, it wasn't in this environment where, political violence was quite as present to the mind as it is now. And so, my own view of the law is that it doesn't necessarily have to be violence. Anything that's going to deter a reasonable person from engaging in a protected First Amendment activity, that's really enough, whether that's employment or social ostracism or, whatnot. Uh, we're not getting a lot of juice for the squeeze and requiring people to disclose $200 donations that pose no risk to the republic and then forcing them to, get into the system. But yeah, no, it was the lowest of low hanging fruit. Basically, just come in and say, you know, here we are, right? Like we have this system of laws. It's incredibly granular and invasive. As I mentioned, $200 disclosure thresholds. In practice, it's significantly lower than that because of complex conduit schemes that I will not bore you with. But very, very small contributions get you into these databases that live on the internet forever. And we had been getting requests from, sophisticated people with good lawyers to have their information, either in whole or in part, redacted from our records because they were, in my opinion, quite reasonably worried about how some of this was going to play out in a hyper-partisan environment. Think back to the 2016 and 2020 election cycles, quite aside from the most recent one, there has been this sort of trend of villainization of the other side that I think is very corrosive to the body politic. And so we attempted to do by regulation what we had been doing informally, which was to quietly behind closed doors, evaluate the evidence of threats to the individual contributor. And if they met the test the Supreme Court has announced, which is a reasonable probability of threats, harassment, or reprisal on the basis of that contribution, to take that off the public record. Um, it was very much an uphill battle. It's a frustratingly difficult thing to convince people of, even though I think in principle, there are very few people who really believe that, the risk is asking people to risk their safety, their employment, over these, especially these small contributions makes any sense. Um, but there's so much entrenched interest in sort of this disclosure is always good. Sunshine is the best disinfectant, which is, a scientifically illiterate statement that somehow is caught on. Um, that it's been very hard to move the ball on that, even though it really should be an extremely low-hanging fruit kind of exercise.
Yeah, I kind of want to follow up on that because it does seem like even if you believe we should have, lots of transparency around money in politics, it wouldn't seem necessary to have street names and numbers. Certain contexts, employer information can be similar. Um, I know the FEC has included in its recommendations to Congress to change the law around that. But what are the real political roadblocks for reform? Because like you said, not a lot of people are really willing to defend this stuff on the merits anymore, and yet efforts to fight it still meet a tremendous amount of resistance.
I think it's cognitive dissonance largely. There's on one hand, behind closed doors, even with very few exceptions, even the people who are the biggest advocates for this sort of, political transparency or nonprofit transparency efforts, like they don't really believe that $20 or $100 contributions need to be public in this way. They don't really believe street addresses need to be attached at least to those. There's very little support in my, anecdotal experience for that kind of granular warehousing of sensitive but frankly kind of useless information. Um, but on the other hand, this is the cognitive dissonance part of it. I think some of those people really do believe that there are vast conspiracies out there, and if they can just find a more granular tool or dig down one more level, they'll somehow unearth these monstrosities that the dragon is out there. We just haven't caught it yet, kind of an attitude. And I think it's difficult for people to reconcile the fact that no, we have extremely granular tracking in this country of this information, too granular in a way that's probably inhibiting a lot of ordinary people from participating in politics. And in your effort to find, some conspiracy theory, pegs on the wall kind of theory of how these things are getting funded through, small donors that are filtered through this or that, you really do end up kind of in a position that's not really reconcilable in terms of these two very different views of how the universe functions. And it's just very hard, even in specific cases, to get people who have built their careers on somewhere out there, there's a shadowy billionaire pulling the strings, and we just have to find precisely how he set up the conspiracy to sort of to talk them off the ledge about, well, one, that's probably not true. And even if it were true, um, making blue collar people making $50 contributions live on databases forever is too high a price to pay for that.
Well said. Yeah, there's probably a sort of Baptists and bootleggers way of looking at the coalitions on this. You mentioned the people who truly believe that those conspiracies are out there, if only we could just find them. And I think they're often taken advantage of by people who very cynically just want to know who's out there talking and giving money about, to influential organizations because as we've seen all too often, when this information does get exposed, it's a way of harassing people and getting them to cease their giving. And I think sometimes there's just that hard-blooded, sort of hardball political calculation of if we can dry up resources to our opponents, it gives us a better chance of winning. And that tends to turn financial supporters of organizations, including nonprofits, into targets in the political arena, which is really unfortunate.
It is remarkable how quickly the conversation shifts from the people deserve transparency to I deserve to know who my political enemies are. Sometimes in adjoining sentences in some of these debates, and it is something of a tell.
Yes, I mean, I believe we've heard that verbatim at times. People don't saying the quiet part loud. They don't even really care about that. Wanted to switch gears a little bit to talk about the FEC where it stands now. Right now, it actually lacks a quorum. You and another of your colleagues have left the commission this year. I know this is a problem you're familiar with because you inherited a backlog because there was no quorum for some time before you joined the FEC in 2020. What does that lack of a quorum mean, particularly for nonprofits and donors? and with midterm elections coming next year, and what do you see being done about this?
Well, I'm in something of an uncomfortable position as the person whose resignation deprived the commission of a quorum. I resigned on the last day of my term, which I felt was appropriate for a lot of reasons. I don't think I think the FEC having a quorum is a good thing, and that probably surprises some of my friends who, know my views on constitutional, matters in this space. And that's for two big reasons. I mean, one is that we haven't really talked about it here, but one of the issues, including in the donor privacy conversation, is how, it's not just that there's a clear rule that X or Y person gets disclosed, or doesn't. Like, a lot of the problem is vagueness and confusion over what the rules even are. And that's, really pernicious because that's the sort of tax on political expression and association that's very difficult to measure. So it's a really pernicious development. And one of the things the FEC can do to be helpful is issue kind of bipartisan interpretations that are very influential when they, in fact, are issued, precisely because everyone understands that they're bipartisan, good faith interpretations of the law. Um, and without a quorum, the FEC is not able to sort of serve that uh, sort of, you know, de-vagarizing like role of providing clarity in the law and the rest of that. And I think that's unfortunate. And as we move into the midterm in particular, there's opportunities for gamesmanship there because there are going to be rules where people who do this for the living on both sides actually agree on what the rule is, and it's going to be individuals who are either less sophisticated or just have more of an axe to grind, who are going to be pushing the debate, and the commission won't be in a position to kind of check that development, which I think is unfortunate and bad for the law and bad for freedom, just generally. So that's the first problem. The second problem, which is more obvious, is that because the FEC is not in a position to act on its own enforcement docket, the likelihood that people will avail themselves of a very technical way to sue people they don't like directly. And that would be a whole 30-minute seminar. So just take me at my word that there's a way for people to get into court against their political or ideological opponents. And that process is easier if the FEC does not have a quorum. And so, the background risk that this stuff's going to be thrown to the courts, where it's going to be more expensive, more unpredictable, where instead of the FEC trying to apply the same rules across its docket in a way that's consistent, it's going to be one-off, targeting particular organizations. I think that's also a very dangerous development. And my hope is that the president nominates new commissioners, preferably of both parties, to restore the commission to functioning order. And I'm sure I and a lot of other people on this call have opinions on what to do from there in terms of, the constitutionality of the act and, where lines should be drawn. But having a functioning FEC, I think, is a good thing in clarifying that debate.
Thank you for your perspective on that. We are starting, we've got about 5 minutes left, so time for maybe one more question here. I wanted to ask you, prior to serving on the FEC, you represented clients, including nonprofits, in challenges to campaign finance laws. You've sued the FEC when you're at the Institute for Free Speech. So you've been in a unique position of having sort of seen this issue from both sides, fighting against the government, working inside the government. What have you learned from that experience?
Well, I think two big things. I mean, one I've already mentioned, the sort of cognitive dissonance where, people don't really like the disclosure regime that exists and think it makes no sense, but they're ideologically committed to chasing dragons and they just can't get out of it. That I've seen both inside the commission and on the outside and, in litigation. The other thing I'd mention is just um, how quickly, the FEC is a very isolated place in a lot of ways. It's got a lot of people of goodwill who have limited experience outside the agency and who really do think of the Federal Election Campaign Act as this Swiss Army knife that's going to fix the republic. And you know, contrasting that inside the building where you have to explain to people there's other things outside of that, like, I don't know, American foreign policy and banks and corporations, like really basic building blocks of society that they just don't think about. Um, and then on the outside, how quickly you realize that, you know, ordinary people don't understand any of this, right? The distinction between political and non-political, issue speech and and political speech, major purpose tests. Like we have all of this jargon we've built up that roughly 200 people understand. And, we're trying to take a continent spanning republic of a third of a billion people and run it on the basis of this software that no one understands, that's creaky, that exists from, the Nixon administration. And, the opportunities for, just good faith misunderstanding turning into gamesmanship when you go even one level down the rung, just to like ordinary people trying to participate in politics, they take one look at this system and they recoil in horror. And I think that that is really an underappreciated problem in this debate, is how all of the experts think this stuff is obvious and fun and whatever, and the ordinary Americans who are actually governed by it have absolutely no clue. And that's not on them, right? Like they're trying to feed their families and participate in their government and go to their churches and all the rest of that. It's not on them to understand this creaky infrastructure we've developed. But those of us who are in this space and in this fight, I think, right up and down the chain, like have difficulty remembering how alien this is to the people we're trying to serve.
That's a well taken point, and it reminds me of Justice Scalia's famous line about campaign finance law being so complex, I believe, that even he had trouble figuring it out. And what chance does any average American have if a Supreme Court justice cannot figure out what the law says? And when the agency is regulating activity that is so core to our fundamental constitutional rights that every American should be able to exercise, certainly with or without a law degree, with any level of education or ability. I think it's really unacceptable to have a body of law that is that arcane. So we are nearly out of time, so I'm going to wrap it up here. Alan, I want to thank you for taking time out of your schedule to be with us here today. I think it was a fascinating discussion. I wanted to invite everyone in the audience to visit our website, unitedforprivacy.com. Follow us on social media. You can find us on LinkedIn, Twitter, or X, whatever you prefer to call it, Facebook, YouTube. We send out a weekly email of media clips with all the biggest news stories and smartest commentary on donor privacy. So I encourage you to sign up for that. And with that said, thank you all for joining us. Have a good rest of your day, and goodbye.